Yes. Good morning, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the Supreme Court Advocate on Record Association to this lecture series. Today, we've all gathered here for one of the important topics of basic rights of arrestee, Article 2021 of the Constitution of India, Article 356 regarding presidential rule, State Article 12 Constitution of India, and Schedule 9 of the Constitution of India for the leading cases exam in the upcoming AOR examination. We have the honor to have with us today Senior Advocate Dr. Purvish Malkan, sir. We welcome you, sir, and we are thankful to you for taking out time. We're showcasing live on YouTube, and if anybody has any questions, the same may be put in the chat box, and the same will be taken up in the end by sir. I'll start with introducing sir. Sir began practice in 2003 in Vadodara District and Session Court, and he later moved to Gujarat High Court. He has served as a central government counsel for High Court of Gujarat from 2005 to 2008, handling direct tax and service matters. He became an AOR in 2009. As an AOR, he represented various companies and entities on issues related to SEBI regulations, insolvency, taxation, civil, constitutional, service, and criminal matters. He has various reported judgments of the Supreme Court to his credit, and Sir is also a visiting faculty in various law colleges, including Symbiosis Law School, Noida. I request you, sir, to please start with your lecture now.
Thank you very much, Meenakshi. In fact, today's topic has been majorly divided into 4 parts. The first part is related to right of arrestee, presidential rule, that is Article 356, proclamation of presidential rule under Article 356, Article 12, that is what is the definition of state, and Schedule 9, the interpretation of Schedule 9 that is been done by the judgment of Supreme Court in IR Coelho. The topic has been arranged by placing right of arrestee as first, presidential rule as second, Article 12 as third, and IR Coelho as fourth. I would rather be taking IR Coelho as first. I will be spending some time in explaining the case of IR Coelho, the background of IR Coelho, because that would be the basics on which we can even go into understanding of S.R. Bommai's judgment and also Rameshwar Prasad. We may also go to the rights as been understood as what has been basics, what fundamental rights would have been construed as a basic structure in IR Coelho, and thereby can also understand the judgment of D.K. Basu and Salvi, the right of arrestee. So it would be better if we understand the background of IR Coelho first, understand IR Coelho, and then we'll go through the other part of the topics if at all it is required. I will try and take all this judgment simultaneously, date-wise as far as possible, as it would be part of understanding of Schedule 9 itself. And we will go through that way. But then if at all it is required to take certain portions separately than what IR Coelho we would be discussing, then we'll take it separately. So beginning with IR Coelho's case, I need to tell you the background of how this Coelho judgment has came into, and what was the background for that. So in fact, in order to give background, we need to start our story like once there was a king. In similar way, I need to start this story as well. Our king then, when we were talking about, once upon a time there was a king. Our king was the ruling government then. At the time of 1950, I'm talking about, when the government of the time, in its manifesto, has came up with the agrarian reform phenomena, equal distribution of lands or equal distribution of resources. That was the phenomenon or manifesto that the government of time who was in place had that in their manifesto of elections. So in order to give way to that manifesto, that political policies that the governance of the time would have for the purpose of equal distribution of land, there had been, after constitution came into place, there had been various Zamindaris Abolition Act. I will go quickly. I will not be taking much details of this because then I'm having limited time. But then quickly going through this, 1950, when this government of time when the Pandit Jawaharlal Nehru was the Prime Minister of the Provisional Parliament. Mind well, the government by the first election of the country was held in 1952. So before that, the parliament in session was a provisional parliament. Provisional parliament was that the erstwhile constituent assembly was made to be the provisional parliament under Article 379 then. And that provisional parliament will function as if it is a parliament for the place till the actual election takes place. So during that period, the interregnum period when the provisional parliament was in place, the Argenian reform, as was the manifesto of the political governance of the political party, these political parties had came up with in various states with the legislations of abolitions of zamindari's laws, um, uh, uh, limitations on sealing acts, etc., whereby the lands of the zamindars were to be abolished, and then it will vest with the government. That was the legislation. Now, having by this time Article 19, right to property in place, various high courts have struck down this legislations as being ultra vires to Article 19, right to property. There had been few high courts who have upheld the uh, the Zamindari's Abolition Act in few states. One of the state which has set aside the legislation was the Patna High Court, where the Patna Zamindari Abolition Act of 1951 has been struck down as ultra vires violative to Article 19 of the Constitution. The said case was been struck down in a famous case of Kameshwar Singh by Patna High Court. That the judgment of Kameshwar Singh was being challenged in the Supreme Court by way of SLP. And then there have been various high courts where there had been struck down of various state legislation, as well as there had been various other high courts who have upheld the state legislations of Zamindari Abolition Act. So there had been conflicting contrary views in the different high courts as far as the Zamindari Abolition Acts are concerned. Certain high court have said that this is a policy of the government, and therefore for the purpose of the policy agrarian reform or agrarian policy of the government, the legislations could not be struck down. That were the reasons given by various high courts, as contrary to the reasons given by Kameshwar Singh in the Patna High Court. These very judgments came up for a challenge in the Supreme Court. Simultaneously, there had been Article 32 petitions filed by various zamindars challenging different Zamindaris Act. And these all challenges were pending before the Supreme Court. Now, when these challenges were pending, the government of time become impatient to the situation as to whether the Supreme Court would struck down the various Zamindari Abolition Act as being ultra vires to Article 19, right to property, and it is directly ultra vires. If it is looked in the literal sense, the All Zamindari Abolition Act was then ultra vires to Article 19 of the Constitution. Therefore, the government of time became impatient, and in order to save that situation of getting or striking down Zamindari Abolition Act and to protect their manifesto of right to property, of equal distribution of resources, the manifesto of equal distribution of properties, they came up with the First Amendment in 1951 itself. The First Amendment was of Article 31A and 31B, which has been placed in the Constitution. Now, Article 31A says that whatever legislation that has been passed in pursuance to equal distribution of resources or equal distribution of land or acquisition of land cannot be challenged in any court. And that's the restrictions has been put on the agrarian reform legislation, that it cannot be challenged, it cannot be questioned in any court of law. Second, Article 31B, which is the topic of this time, wherein the AOR Coelho will come into place. The AOR Coelho has to interpret Article 31B in its sense. So this is the article which has been interpreted by AOR Coelho. Much after various interpretations given by various judgments, AOR Coelho put it straight as to actual sense of Article 31B, as to in what manner Article 31B would be applied. And that is what we will be looking at. So Article 31B came up with an excellent idea. It has completely turned the fundamental rights under Part 3 of the Constitution, which has been guaranteed to the citizens of India by way of Constitution, had been taken away completely, had been actually, put to its head, rather, I would say, completely by putting Article 31B in place, whereby Schedule 9 has been incorporated in the Constitution. Now, what does it say? That when there are certain legislations which, even if it violates Part 3 of the Constitution, that is fundamental rights of the citizens of the country, even if it violates, but such legislation, if are placed by way of Constitution amendment within Schedule 9 of the Constitution, then such legislation cannot be challenged as it is being ultra virus to Part 3 of the Constitution. I may just repeat, because that is where the Article 31B underlining provisions are. I will repeat for your understanding. It says that when a legislation, even though if it violates any of the provisions of Part 3 of the Constitution, if such legislation are placed within the umbrella of Schedule 9, within the protection of Schedule 9 of the Constitution, then such legislation cannot be challenged as it being ultra virus to the Constitution, and it has a protection. It further says that any legislation which by now has been held ultra virus to the Constitution, but if they are placed under the umbrella of Schedule 9, that legislation will, and the judgment declaring it ultra virus will be nullified. So any judgment by now, so I said that there had been various judgments wherein various states had been declaring the Zamindari Abolition Act to be ultra virus. Such legislation
Uh,
and then the legislation will revive. It will pass the muster of constitutionality. That's what the Schedule 9 is all about. So it has a protection contrary to the Article 13, which says that any legislation which is in violation of any law or legislation which is in violation of Part 3 of the Constitution would be void. That's Article 30. Now, completely contrary to that, 31B place Schedule 9 in place and says that any legislation having protection of Schedule 9 cannot be challenged as being violation of Part 3 of the Constitution. Therefore, this is an exception. The exception has been carved out in order to take away your fundamental rights. That's the Schedule 9. That's the whole and soul of Schedule 9. So, this exception is the question of IR Coelho. As to what extent can you take away or abridges the fundamental right of the citizens. Now, after this, 31A and 31B came into place. This very judgment was challenged in the first case of 1951, which is known as Sankari Prasad Deo versus, in the case of Sankari Prasad Deo versus Union of India, AR 1951, page 458. Now, in that judgment, ultimately, Supreme Court said that the amendment under Article 31A and 31B, First Amendment, Article 31A and 31B, is a constitutional amendment. And this amendment, even if it abridges Part 3 of the Constitution, cannot be set aside by construing it to be law under Article 30. It says that there is a difference between ordinary law and constitutional law. And therefore, it cannot this constitutional amendment cannot be equated as an ordinary law and therefore cannot be set aside, and therefore upheld the very first amendment in Sankari Prasad. I will just quickly move ahead. So after this, under the First Amendment of while incorporating Schedule 9 in place, there are 13 legislation had been placed under the protective umbrella of Schedule 9. So there have been 13 legislation in the very first amendment, which has been enlisted in Schedule 9, which they had been violating Part 3 of the Constitution, but cannot be challenged as ultra-virus to the Part 3 as it is protected under Schedule 9. So there have been 13 such legislations which has been protected, admittedly to be in violation of fundamental right of the citizens, maybe right to property, right? First, because it's a First Amendment, it was for the purpose of agrarian reform. So it is majorly violating fundamental right as to right to property, right to hold property, zamindaris. Then come Fourth Amendment. So after this Sankari Prasad DO's judgment was upheld first constitutional amendment, then came Fourth Amendment, whereby about 7 Act has been again incorporated in Schedule 9. So list has gone from 13 to 20. So First Amendment, 13, Fourth Amendment, 20 legislation has been given protection of the Schedule 9. And then in 17th Amendment, there had been another 43 acts which has been incorporated under the protective umbrella of Schedule 9, and the list went up to 64. Now, in this 17th Amendment, there had been various other legislations which is related to industrial disputes, which has no relation to the agrarian reform, but now has given protection of Schedule 9, completely contrary to for the purpose and object with which First Amendment came into place. So, and thereafter, there had been n number of legislations which has been incorporated in Schedule 9, which is not related to agrarian reform, but has a protection of being challenged in the courts of law. This 17th Amendment, as I said, which is list of about 63 now, came up for a challenge before the Supreme Court somewhere in 1963 in the case of Sajjan Singh. Now, in the case of this Sajjan Singh, again, Supreme Court has gone into the validity of Article 31A and 31B, and ultimately found that whatever has been said by the Sankari Prasad's case was a correct view, and then law cannot be equated as the ordinary law. This constitutional law cannot be equated with the ordinary law, and upheld the constitutionality of 31A, 31B, and amendment made up to 17th Amendment, incorporating about 64 legislation within the penumbra or within the umbrella of the Schedule 9. Now, this is the time, 64 is the time when there had been a political disturbances in the country. If you remember, 64, Pandit Jawaharlal Nehru died, the first Prime Minister of the country died. And there had been disputes as to who shall be the Prime Minister, but then Lal Bahadur Shastri was appointed as a Prime Minister in 64. In 65, our country has faced various economic crises, including war with the Pakistan, with the China. And there had been drought situations during 64, 65. So our country faced extreme economic crisis. In addition thereto, the Prime Minister died in somewhere in 1966. Again, Lal Bahadur Shastri died. And therefore, there was again a problem within the nation as to who shall be the Prime Minister. And there was a dispute existing between Morarji Desai and Indira Gandhi. Ultimately, Indira Gandhi won the secret ballot within the Congress, and Congress member of Parliament, and she was been elected as a leader of the member of Parliament, and ultimately became the Prime Minister. But then she was about to face the elections immediately within a year, and at that time she need to show something to the country as to what she can do. And therefore, in order to prove herself, she came up with two good ideas. First idea was of bank privatization. Private bank converted into nationalization. So nationalization of bank was the first idea she came up with. And second is abolition of a privilege. So after this Sajjan Singh, these two issues were propped up. And then again, she could come up, see her two policies of this bank nationalization and abolition of privy purses could not hold good before the courts, before the Supreme Court. And both these policies have been struck down. The first bank nationalization policy was struck down on the ground of inadequacy of compensation to be paid. And the privy purses has been struck down as incompetent. The incompetency by way of legislation to abolish the provisions of privy purses as prevailing in the constitution. So these are the two major setbacks that Indira Gandhi faced. And therefore, she came up with two amendments, that is 24th Amendment and 25th Amendment. 25th Amendment and 26th Amendment. 25th Amendment is to is to bring in Article 31C in place, and 26th Amendment was to abolish privy purses. Before that, there was a case of Golaknath, which has laid down that the fundamental, that by that time, when the Golaknath was pronounced, by that time, the fundamental right are construed to be superior one, and therefore Golaknath says that no law under Article 13 can be abridged as violation of fundamental right, and therefore it says that constitutional law is also is a law under Article 13, and it also cannot abridge fundamental rights, and thereby said that the fundamental rights are supreme, and it actually, if it, and thereby it set aside Article 31A and 31B. It quashes Article 31A and 31B completely. Having said that, in Golaknath, the government need to overcome the judgment of Golaknath. Therefore, it came up with the amendment under Article 24th Amendment, whereby Article 31C was being placed. This is the first time Article 31C was being placed, whereby directive principles, the legislation, directive principle has been given priority over the fundamental right. Where it says that any legislation which has been passed for the purpose or in consonance with directive principles of state policy, same cannot be challenged as being a violative to the Part 3 of the Constitution. So again, this directive principle has given privacy. Above, has been placed above the fundamental rights. So having this three amendments, Article 20, Amendment 24, 25, 26, and Amendment 29, whereby certain legislation of Kerala, Zamindari abolition again, has been placed under 9th schedule. These four amendments had been challenged in the famous judgment of Keshwananda. Now, Keshwananda, you all know, ultimately come up with the principles of basic structure. It actually, by very thin majority, thin majority of 7:6, it came up with the concept of basic structure doctrine, which says that the Constitution can be amended, but to the limitation of the basic structure doctrine. This is the limitation placed under Keshwananda. After Keshwananda, Indira Gandhi lost elections. You all know that, and Indira Gandhi lost her case against Raj Narayan, Allahabad High Court, challenged before the Supreme Court, and in order to overcome this judgment, again 39th Amendment was placed, whereby the Prime Minister, President, Speaker, and Vice President has been put above the law. It says that elections of these authorities cannot be challenged, and if at all it has been set aside, then such judgment would be invalid, and thereby invalidating judgment of Allahabad High Court. I will not go into much details because you all are aware of that. Indira Gandhi versus Raj Narayan. That is 39th Amendment which was placed. Now 39th Amendment was challenged again in the Supreme Court, considered, and the 39th Amendment was set aside as being ultra vires of the basic structure doctrine, which has been recently placed by Keshwananda. After this Indira Gandhi's judgment, there had been 42nd Amendment, which has came up with series of amendments in the Constitution. It came up with various drastic amendments in the Constitution. We are only concerned with one amendment, which has placed in under Article 368. It brought in two articles, Article 368 subclause 4 and 368 subclause 5. This 42nd Amendment was brought into place for a limited purpose. It actually tried to overcome the Keshwananda basic structure doctrine. So under Article 42, by placing Article 368, 4 and 5 in place, it says that any legislation which has been placed by a way of constitutional amendment cannot be challenged in any court of law, irrespective of its violation of the Part 3, but it cannot be challenged. And any judgment declaring any constitutional amendment to be void is hereby made redundant. So that judgments of Keshavananda was made redundant under Article 368, 4 and 5. This very judgment was being further considered in Minerva Mills. And Minerva Mills, now this is where the topic of the time starts. So judgment of AOR Coelho has relevance with this judgment of Minerva Mills. So Minerva Mills does set aside Article 368, 4 and 368, 5. It set aside that. But it further, while interpreting Article 31C, as I said, that Article 31C has said that the directive principle would be having primacy over the fundamental right. Therefore, any legislation which could have been passed for the purpose of directive principle could not be challenged on the ground that it violates fundamental right. Now, this issue was being considered in Minerva Mills, whether Article 31C could be held to be constitutional or is being violative of basic structure of the Constitution. Because can the directive principles be placed over and above the fundamental rights? The Minerva Mills does interpret that directive principles cannot be permitted to override fundamental rights. That it interprets. It further says that directive principles, there could be legislation which could be violative of part 3 of the Constitution, which could be violative of fundamental rights. Contrary to that view, now, and please understand this, contrary to that view, there was a judgment of Vaman Rao of the same year, which says that any legislation which has been passed for the purpose of directive principles of state policy cannot violate fundamental right. It says it is not true that it could violate fundamental. Minerva Mills says that there could be instances where in order to have fundamental right in place, directive principles legislation could violate that. These are the two conflicting views of the judgments. In order to settle this difference on this issue, a reference was made in AOR Coelho. Now, AOR Coelho has, in my reading, I may be wrong, but in my reading, has started with a wrong footing. It starts its judgment, and in various places it repeats by saying that validity of Article 31A and 31B was not in consideration before the court. The validity of Article 31A and 31B is not in consideration, which I find it to be incorrect for the simple reason that validity of Article 31A and 31B was being considered in Vaman Rao itself. And Vaman Rao does upheld Article 31A and 31B on the ground that it has been in place for a long time and that it is for the purpose of agrarian reform. And for the purpose of agrarian reform, such policies, such articles are necessary. And therefore, that validity was there in Vaman Rao, and AOR Coelho is the reference of Vaman Rao. Therefore, the issue of validity of Article 31A and 31B was there in question before the Coelho itself. But in my opinion, and I may be wrong, the Supreme Court, is my comment on the judgment of the Supreme Court, that Supreme Court has, by saying that these two are not, the validity of that, these two provisions are not in question. And therefore, they went into only an interpretation of the provisions of Article 31A and 31B. Now, our issue is interpretation of Article 31B made by AOR Coelho. Now, in IR Coelho, it has been interpreted. Now, this is how the interpretation of IR Coelho comes in. IR Coelho says that there could be instances where the legislation, though given a protection of fundamental right under Article 39B by placing under the Schedule 9, it would have violated Part 3 of the Constitution, fundamental rights of the Constitution, fundamental rights of the individual. It therefore goes on to the scrutiny as to what would be the value of fundamental right, whether this fundamental right could be construed to be the basic structure of the Constitution. The important thing in IR Coelho is that it says, and please note this down, it says that certain rights under Part 3 does form part of basic structure of the Constitution, though it does not enlist which of the fundamental right would be falling within that ambit. It says that it does form part of the basic structure, but which part is not been clarified. It also says that this our triangle, Article 19, 14, and 21, that could be one of the part wherein the basic structure would be revolving around. It further says that any provisions of a legislation which has been given the protection of Schedule 9, if at all it violates Part 3 of the Constitution, then first test would be whether that violation of that fundamental right is that fundamental right forming part of basic structure. If answer is yes, then that legislation could be construed as violating basic structure of the Constitution, and that can be set aside to that extent. It lays down a test now that if the legislation which is given a protection umbrella of Schedule 9, if it violates the fundamental right, then test would be whether that fundamental right itself is a basic structure or not. And if it is the basic structure, then yes, that legislation could be set aside. Now, then it further says, it doesn't then define which fundamental right would be basic structure. It says that it is left open for the concerned courts to consider the facts of each case and to decide as to whether the fundamental right being violated in that case could be covered under the penumbra of or within the ambit of the basic structure or otherwise. This is how it says that the legislation being placed within Schedule 9 of the Constitution, protective umbrella of Schedule 9 of the Constitution, can only be tested on the touchstone of violation of a basic structure of the Constitution and nothing else, and no further test could be applied. This actually has laid also down the concepts of judicial review and has understood that has construed that the courts would have power to review judicially the constitutional amendment actions made by the parliament. And thereby it also says that the judicial review is also part of the basic structure doctrine. It also relies upon Sampath Kumar and S.R. Bommai's case, which has been decided earlier, wherein the judicial review has been construed to be part of the basic structure in order to review the constitutional amendment, which has placed legislation in the purview of Schedule 9. This is the underlying provisions of IR Coelho. Now, having said so on IR Coelho, let us move to because I have taken ample of time on Coelho, let me move quickly to the issue of S.R. Bommai and Rameshwar Prasad. Now, coming to the facts of S.R. Bommai's case, there had been various certain states wherein the proclamation had been issued by the central government of time, whereby under Article 356, laying the state emergency and applying the presidential rule in various states. The states which have been part of this was Meghalaya, Nagaland, and Karnataka are the three states whereby the presidential rule has been imposed because of political disturbances within the state. Political disturbances meaning thereby that there had been some issues with related to having confidence in the ruling government of time of the state by the oppositions. So there had been political disturbances about the claim of uh, motion, and Nagaland. The central government issued proclamation under Article 356. These are the broad facts of these three states. There are other states like Madhya Pradesh, Rajasthan, and one more. Madhya Pradesh, Rajasthan, and Himachal Pradesh, wherein disturbance was because of the Ram Janmabhoomi issue, Babri Masjid Ram Janmabhoomi issue at the relevant point of time, where the government of the time of the state made various statements as respect to the which could said to have been disturbed the very secular nature of the country, and thereby a proposal was made by the governor that the the statements of the ruling government of the state is such that it could disturb the secular nature, that is the very basic feature of the constitution, and thereby the state has failed in performing its constitutional uh, function. These are the two different types of facts which has been considered in SR Bombay. Now, that are, apart from that facts, the issue majorly is whether the courts can look into the proclamation issued by the president, if at all, and to what extent. Whether the proclamation under Article 356, which has been passed by the President of India upon the recommendations of the cabinet ministry, and the recommendations made by the governor, whether it can be at all be considered by the judiciary, can be looked into, can be tested by the judiciary at all. In fact, if you remember, Article 74, subclause 2 says that the any aid and advice given by the cabinet to the cabinet to the president cannot be tested in the court of law. Now, this is also based upon an advice. The issuance of proclamation under Article 356, laying down emergency in the states, are also based upon the advice given by the cabinet, and therefore issue is whether it can be tested. The Supreme Court says that the concept, again, it goes on the concept of judicial review. And it says that judicial review is the basic and essential feature of the Constitution. It is necessary that the government of the time, that the central government of the time does not exceed its function to disturb the federal structure of the Constitution. The state and the union, are the separate, and we are in a federal structure, though it's a quasi-federal, not exactly a federal structure that what US would be having. But we follow the federal structure, federalism in the country. And therefore, the court says that when this federal structure of the nation is being curtailed by way of proclamation, it is necessary for the court to look into as to whether such exercise has been done in a judicious manner or otherwise, whether it's an arbitrary or not, is to be tested. Now, in order to test that, the court laid down three tests. It says the decision of the president while issuing proclamation, write down this. Decision of the president while issuing proclamation must be based upon relevant material. So first thing what would be required is there has to be relevant material. Merely recommendation of a governor saying that the state has failed in constitutional function is not at all relevant, not at all relevant material. The president need to have complete facts by itself to issue the proclamation. Merely he cannot rely upon governor recommendation without actually verifying the true facts. The second, it says bona fide. The proclamation must be bona fide. it must not be for the political purpose. Now, what happens is that government of a ruling party of in at the center, they majorly try and take over the states on their hands. As if you remember, there had been a time when the Janata Dal government was in place. It actually, uh, by one ordinance has curtailed the legislation of various states, and which has been ultimately set aside. Let's not get into it. But then the purpose of the proclamation has to be bona fide. It cannot be for the political reasons. It has to be for the reasons that the state government has actually failed in its constitutional function. That has to be bona fide reason. And third would be that the facts which has led to issuance of a proclamation are of such nature, such an extreme nature, that there is no other option but to issue proclamation in this state. It has to be such an exigencies must prevail to issue proclamation in this state. Unless these three tests are satisfied, and if proclamation is being issued, then such proclamation can be set aside, and it ought to be set aside. In the subsequent judgment of Rameshwar Prasad, when the proclamation was issued for state of Bihar, the court came up with the further Supreme Court came up with further findings on or further observations on whether status quo ante could be applied on the proclamation, and the situation could be restored, whether situation could be restored which it was prevailing prior to the proclamation or not. That power of judicial review, that power of judicial activism is being shown by the Supreme Court in these two judgments, whereby they upheld the test to to consider the validity of proclamation issued by the president under Article 356, the highest authority in the country. And also, in the subsequent judgment, it come up with with the concept of applying status quo ante and to restore the position prior to the presidential rule. So these were the two situations where the Supreme Court has come up with. Supreme Court has also given a finding on the secularism being the basic structure of the constitution for the three states like Himachal Pradesh, Madhya Pradesh, Himachal Pradesh and Madhya Pradesh, which I said that to be, wherein the disturbance was because of the Ram Janmabhoomi. Now, in that states also, the Supreme Court has said that any statement made by the government in power of the state, which is contrary to the secular nature of the country, could be amounting to the infringing the constitution, and thereby the functions of the constitution, and thereby the very state or very government cannot be said to have been performing the functions according to the constitution, and therefore it upheld the proclamation under Article 356. So three major issues. First is judicial review was held to be part of basic structure in the judgment of S.R. Bommai. Second is secularism was also construed to be part of basic structure. Any attack on secularism was held to be attack on the constitution by the government, and thereby such government cannot be allowed to continue within that state, and thereby the proclamation of that state upholding the emergency was upheld. And in the subsequent judgment of Rameshwar Prasad, the issue of status quo ante was considered again, and has came up with the finding that court has a power to restore the position as it was prevailing prior to the proclamation of the president. So this is the judgment on the proclamation of Article 356. Now coming down to the issue of state, what would be the state? Now that's where the judgment of Pradeep Kumar comes into play. Now in the case of this Pradeep Kumar, the issue actually has arisen because of the earlier judgment of Supreme Court in the case of Shahbazit Tiwari, that is of 1975. Now, in this judgment of Shahbazit Tiwari, the Supreme Court has held SIR, the Council for Science. One second. It is CIS. One second. What is it? Council of Scientific and Industrial Research. CSIR. I'm sorry. CSIR was not the state judgment of the Supreme Court in the case of Ajay Hasia. The interpretation as to what would be state within meaning of Article 12 has been completely different. So, in this judgment of Pradeep Kumar Biswas, again an issue came up as to whether this CSIR could be a state or otherwise. The High Court has relied on the judgment of Sabhajit Tiwari and said that Supreme Court has already upheld in 1975 that CSIR is not the state. When the issue came up before the Supreme Court has considered the contrary view taken in Sabhajit Tiwari and the contrary view in Ajay Hasia. Sabhajit Tiwari said in the 1975 that in order to determine the particular institution to be state, what is required would be that institution should have the authority by way of statute. It must be having an authority by way of statute. Merely having funded or dominated by the government is not sufficient. It must be having a statutory authority in order to come up within the ambit of state. That's what Sabhajit Tiwari has said. And thereby it says that CSIR is not a statutory authority, but a society registered, though controlled by the central government in the management, but is not a state. In Ajay Hasia, Supreme Court has come up with a concept which is called as dominance of the governance. Dominance of the governance over an authority. So if an authority is having a dominance of the government, meaning thereby if the authority or the entity of which is in question, whether it is a state or not, if it is an entity wherein the management is being controlled by the state government or the central government, or it is being funded partially or fully by the central government or state government, then in such circumstances, the authority could be construed to be a state within the meaning of Article 12. It lays down further test, and that is the important test of Ajay Hasia. It says that if an entity is having a function of a governance, now functioning of a governance is an underlining term, functioning of a governance. Now it is not the entity who is actually governing, but its functioning is of a governance, then such entity could be termed as a state within a meaning of Article 12. Now that means that if it is not being dominated, managed, funded by the government, it is not a statutory authority by the government, by the law. But if its functions are such that it could be related to public functionary or the public functions, then such entity could be termed as a state. That's what Ajay Hasia has laid down. Now, in order to see what is the underlining term of whether it has been a public function or not, the single line understanding of this term would be whether the entity is entangled. Now, write this term if at all possible for your purpose, is to whether entity is entangled into the public function. That's the underlining point. Entanglement into a public function. If it is so, then such entity could be termed as a state. Now, having considered the judgment of Ajay Hasia and relying upon that, the Supreme Court ultimately has held that CSIR, which is having a dominance of the central government, whereby the central government is the authority who actually is part in the management, day-to-day administration of these CSIR institution, and thereby such institution, though being is a society, though being registered as a society, could be termed as a state within the meaning of Article 12 of the Constitution. This is the judgment on the state. What would be the definition of state? And the underlining term, for your purpose of our examination, please mention this, that it has to, if it is into the public function or its function is such that it is entangled into government functionaries, then such institution could be termed within Article 12 of the Constitution. That is definition of a state for the purpose of Part 3 of the Constitution. Coming down to the last issue of the day, that is the judgment on D.K. Basu and Salvi. Now, these are the two judgments which has been of the time. So let me go to first, that is D.K. Basu. Now, D.K. Basu is the time when there had been atrocities on the arrestees while they were in custody by the police. The brief facts of these cases are that there had been atrocities in the various states. And this case is arising out of state of West Bengal. So initially it started with the case of West Bengal. So there had been atrocities in West Bengal by the police in their custody, and various deaths has been reported in various news items. Day in and day out, there had been reports of deaths in the police custody. So this Supreme Court was in receipt of a letter of this police atrocities to the person in custody, detaining. And they took up this issue as a suo motu. While this issue was pending, there had been another report in different state of death in police custody, and which shook the conscience of the Supreme Court, that when the Supreme Court is seized with the matter, such matters, and there is continuation of such incidents in the country, and thereby it thought to give some directions to the state as to what should be the requirement of the police at the time of a detention of an individual, and what would be the necessary procedure that police need to follow for the person who is being detained, so that such atrocities could be avoided. It actually gives the directions under Article 142 of the Constitution of India, laying down certain measures. There are about 11 measures which has been highlighted. I will name one after the other. If you want, you may take note of it. So it says that if a person is being detained, the identification of a person detaining must be informed. So person who is being detained, the identification of person detaining, so the police officer who is being detaining the detainee, his name, the name of the police officer must be informed first. His identification has to be given properly to the person who is being detained, so that the individual could understand as to who is the person who is actually detaining him. That's first. Second is, the arrest memo should be written immediately at the time of arrest. Arrest memo is necessary. That's the second. Arrest memo necessary. Arrest memo must be in presence of a witness. So there has to be one witness to verify as to person who has been detaining an individual is being detained properly without any harassment. And then signature of that witness as well as the detainee is required under the arrest memo. That's two. So the arrest memo or by the person detaining. Third, the information about the detention must be given to the relative of the person detained or his friend, either if detained's relative are not available, to the next friend, whosoever is available around, who is concerning about the welfare of the detainee. The information about the detention should be given to that individual. If supposedly no one is available, neither the friend is available nor the relatives are available, then information must be given to the jurisdictional legal aid organization. Jurisdictional legal aid organization about the fact of detention of individual within 12 hours of the detention. So this information about the jurisdictional legal aid organization must be passed on within 12 hours of the detention. If at all, neither relative nor the friends are available. Fifth, the individual would be made aware about his right and be informed about his right to remain silent. That's one, to get the help of the lawyers if at all he wants. So this information must be given to him about his rights. Sixth, the detention must be immediately recorded in the diary, station diary of the by the person detaining, and the name of the person who has been informed about the detention must also be mentioned in the station diary. This is sixth. 7. So a person who has been detained, he must be inquired about his medical conditions. So that is whether he has been any injuries. He must be checked for his injuries, about his medical conditions, any medicines that would be required. That information are necessary to be collected by the person detaining. And after detention, detainee must be taken for medical examination every 48 hours. So he must be tested medically every 48 hours. These are the requirements of the person being detained. Now, having this measures being laid down by the Supreme Court for the protections of a person who has been detained from being from the atrocities of the police. What further the Supreme Court has said is more important. It actually affirms the principles of a tort in this criminal procedure, in the criminal jurisprudence. It says that whosoever has been detained illegally, whoso have been under custodial harm or custodial atrocities by the police, then in such circumstances, state is required to pay damages or compensation to such detainees, to such persons. So this is how the concept of damages has been placed into place by the Supreme Court. And this is again a part of judicial activism in order to protect the atrocities by the police authorities. It further says that any police authorities or any authorities being in violation of the measures enlisted herein above shall be liable for civil contempt, and that contempt can be issued by the high courts. So these are the measures which the Supreme Court has come up to protect the custodial atrocities. The last is the judgment of Selvi. Now, in this case is very narrow. The case is whether there could be a narco-analysis test be performed on an individual without its consent. The concept of fruit of poisonous tree is not available in India. This concept is alien to India. We don't follow that. We say that whatever evidence, if it came to the light of the day, it has to be read. It has to be relied upon. We don't rely upon the concept of that if that evidence is obtained illegally, then such evidence could be discarded. We do not believe that. We believe that every evidence which came to light has to be relied upon. This is the principle that India follows. Now, be that as it may, whether that evidence could be obtained illegally. That's the issue. Now, here, the concept of narco-analysis performed on the accused, could it be done without its permission? That's the question before the Supreme Court. Now, Supreme Court says that no person, and the clear concept of criminology is that no person shall be compelled to incriminate against himself, to speak against himself. He cannot self-incriminate it, right? No one can be compelled to self-incriminate it. And if it is, and that's why we say that that the confession that we give before the police cannot be used against the individual himself, because it is the self-incriminating statement made and cannot be used against himself. So therefore, now this narco-analysis test, whether it can be performed without the consent, it says that if it is without the consent, privacy of a mental status, mental ideas, your memories, privacy of your memories, which need to be protected under Article 21. You have your own memories of certain facts, which you don't want to disclose to public at large. You don't want to tell anyone. There are certain hidden facts which you need to keep with you. You don't want to disclose it. If such tests are being performed without the consent, then there are chances that you may also disclose. You may disclose whatever you want to keep it for yourself. Such would be infringing your right to privacy of Article 21 of the Constitution. And therefore, Supreme Court says that such test without consent would be violating Part 3 of the Constitution of India, violating 21 of the Constitution of India as and right to privacy, precisely. And therefore, such test cannot be performed without consent. But yes, with consent, it can be. So consent would be necessary to perform narco-analysis test. I think with this, I have taken sufficient time. I suppose I have completed my lecture within time. If at all there are any questions, I'll be happy to answer.
Thank you, sir. It was actually a delightful lecture. My concepts got cleared, a lot of them. I'll
Thank you.
just take the question, sir. The first question has been asked by Mr. SRV. He's asked that in light of the Rameshwar Prasad case, could you please explain the judicial activism and judicial review over
Yes.
judicial overreach in any recent case? And can we say that Ajay Hasya has been fully upheld in the Rameshwaram case?
See, Ajay Hasya and Rameshwar Prasad are different cases. Ajay Hasya is a case wherein definition of a state has been defined. What would be the nature of authority falling within the ambit of state? What would be the state? So Ajay Hasya has nothing to do with Rameshwar Prasad. Rameshwar Prasad is the judgment when there was a proclamation came to be issued under Article 356 as far as the state of Bihar is concerned. This is the first time, I may tell you, in Rameshwar Prasad case, this is the first time when the proclamation by the president has been issued before even first meeting of the Legislative Assembly.
Oh.
For the simple reason that there was no clear majority to any of the party but in that election, and therefore there was uncertainty as to which party would be able to form or would be able to get confidence. The governor thereby has actually made a recommendation to the president that there could be a horse trading, there could be chances of horse trading within the state, and thereby it recommended for presidential rule, and thereby president has came up with the proclamation under Article 356. The Supreme Court says that the chance could have been given to the political party whom governors thought it fit could have majority, could get the majority in the House by a floor test. Floor test would have been permitted. Without the floor test, the recommendation by the governor is not proper. This is what the Supreme Court has said. The floor test is necessary. That was the underlying principle that Supreme Court has said. And thereby Supreme Court has stated that because of such action, the floor test has not been permitted. the judicial activism comes into place when Supreme Court says that it would be necessary, therefore, to restore the position before the proclamation came to be issued. And thereby, that was the issue of judicial activism.
Right, sir. The second question has been asked by Mr. Rajesh Kumar. He's asked that, sir, is there any specific reason not to direct Parliament to make law in line with the DK Basu guidelines as it was in the Vishakha case?
So, in fact, I may tell that, see, there are Supreme Court, we know that we as a judiciary is a separate wing than that of Parliament. Judiciary cannot and can never, even in Vishaka, there could be a suggestion that such legislation would be necessary. But I may tell you, Supreme Court can never direct as to what legislation should be enacted by the Parliament. It is at the wisdom of the Parliament, the nature of legislations to be passed. Any interference or directions by the Supreme Court by way of directions to come up with the legislation would be overstepping the judicial activity and stepping into legislative activity, which is not permitted.
The last question has been asked by Mr. SRV again. He's asked that if you have time, could you kindly bullet point the Panchsheel test in Sarad Bitihara, though not relevant in the DK Basu, but connected to criminal jurisprudence of circumstantial evidence?
So it will require some time. I will do that for you. I will get me your email. I will definitely do that and send it to you. I will do that. Of course, I will be happy doing that.
And the last question by EC SCAORA is, if you can share your notes for today's lecture.
I will definitely. Will do that. So I have handwritten notes, but I will share. I will type it and share it. I will type it and share it. I have handwritten notes. I will type it and share it. Thank you.
Thank you so much. Conclude with the vote of thanks. I, on behalf of the Supreme Court Advocate on Record Association Executive Committee, I extend a heartfelt gratitude to you, sir, for being an esteemed part of the SCAORA AOR Lecture Series 2025. Your illuminating insights on the judgments and related important topics have been invaluable. I'm sure a lot of aspirants who are watching this lecture will gain from your in-depth knowledge, just like me, and your skills as a law faculty, I'm sure, shows the effort that you've taken in this lecture. And your thoughtful analysis has provided clarity on important questions, giving aspirants a significant edge. I appreciate your gracious presence, sir, and we look forward to have you again on board for the future AOR lecture series. Thank you, everybody who's watched this lecture in large numbers. I, on behalf of the SCAORA, wish everyone the very best of luck for the upcoming AOR exams. Thank you, sir.
Thank you very much. All the best to all. Thank you. Thank you.